Welcome again to Florida Appeals Journal. I'm Jennifer Carroll, and today we're going to talk about post-judgment relief. Fascinating remedy. A few people really have a handle on it. This is a remedy you have. It's not an appeal. It's a motion you would file in the trial court. So if you have a judgment or an order, and they have to be final orders and final judgments, and you have the right basis upon which you can launch a trial court challenge to it, you can invoke Florida Rule of Civil Procedure 1.540. Memorize that rule. It's a great rule to have. I'm going to quote from it because that says everything about the rule. First of all, with respect to clerical mistakes in judgments, decrees, or other parts of the record, and errors therein arising from oversight or omission may be corrected by the court at any time on its own initiative or on the motion of any party, and after such notice, if any, as the court orders. And something to know is during the pendency of an appeal, such mistakes can be corrected before the record on appeal is docketed in the appellate court, and thereafter, while the appeal is pending, may be so corrected with leave of the appellate court. Now, subsection B, that's the key section, and that's most motions for relief from judgment or motion to vacate the judgment are filed under subsection B of Rule 1.540. So I'm going to read the main part of it because that's gives a great explanation of the rule. So first of all, the rule is titled Rule 1.540, and it's a rule of civil procedure, relief from judgment, decrees, or orders. Subsection B, mistakes, inadvertence, excusable neglect, newly discovered evidence, fraud, etc. What's etc.? Well, you have to review the cases to find that out, but I'm quoting the rule. On motion and upon such terms as are just, the court may relieve a party or a party's legal representative from a final judgment, decree, order, or proceeding for the following reasons. 1, mistake, inadvertence, surprise, or excusable neglect. 2, newly discovered evidence, which by due diligence could not have been discovered in time to move for a new trial or rehearing. 3, fraud, whether heretofore denominated intrinsic or extrinsic, misrepresentation, or other misconduct of an adverse party. 4, that the judgment or decree is void. Or 5, that the judgment or decree has been satisfied, released, or discharged, or a prior judgment or decree upon which it is based has been reversed or otherwise vacated, or it is no longer equitable that the judgment or decree should have prospective application. And I just want to say one thing about that last number 5. That's always a very good catch-all because you may have, like on a main appeal, main judgment gets reversed, and you may have an order relating to that judgment dependent on that judgment. You can always invoke, if that was not appealed, that subsequent order wasn't appealed, you can invoke sub 5 in the trial court and say, hey, it's no longer equitable to have this order in effect because the judgment upon which it was based was reversed on appeal. So that's a great section of the rule. Then continuing with the quote, the motion shall be filed within a reasonable time and for reasons 1, 2, and 3, not more than 1 year after the judgment, decree, order, or proceeding was entered or taken. So remember 1, 2, or 3, mistake, inadvertent, surprise, or excusable neglect is number 1. Number 2 is the newly discovered evidence. And number 3 is fraud. Okay. A motion under the subdivision does not affect the finality of a judgment or decree or suspend its operation. And the rule does not limit the power of a court to entertain an independent action to relieve a party from a judgment, decree, order, or proceeding, or to set aside a judgment or decree for fraud upon the court. That's the rule. Follow it with T. And it gives the grounds in any motion that you would do you definitely want to follow these grounds specifically. Now, in these kind of cases, at first I want to say, because I've seen where some people, they'll call it a motion for reconsideration. They won't title it right, and that'll confuse some trial judges, especially if they're going through quickly. So I think it's always a good idea to put the rule in the title of your motion. And typically you would say it's a motion to vacate judgment X under Rule 1.540. So I think that's very important. Okay. So when you do your motion, you write up your motion, you want to state your grounds specifically, and especially when you're alleging fraud, because you need to show if there was a fraud committed upon the court. And there are cases that define extrinsic, intrinsic, and depending on which one, usually it is within the year, but I believe if it's the extrinsic, you can go beyond the year. But you need to lay out the specifics in that motion. Here's why that's very important, because you've got a shot at an evidentiary hearing. If you can state a colorable claim, you have the facts, you may supply affidavits, attachments with that. You want to ask for an evidentiary hearing. You don't have to, but in order for the court to give you an evidentiary hearing on your motion, and most of the time the court will, especially in fraud cases, but you need to state a colorable basis for relief in the motion in order for the trial judge to be justified in giving you an evidentiary hearing. So I'll just quote, there's a Dynasty Express case, 675 Southern 2nd, 235. That's a 4th District 96. There are actually several cases on this point, but I'm going to quote, if allegations in moving parties' motion for relief from judgment based on fraud raise colorable entitlement to relief, formal evidentiary hearing on motion, as well as permissible discovery prior to the hearing is required. In order to warrant an evidentiary hearing, the motion must specify essential facts of purported fraud and not merely assert legal conclusions. So that's very important. And again, as I was saying, the whole purpose of that requirement to specify your essential facts is to allow the trial court to determine whether the movement has set forth a prima facie showing which would justify relief from judgment. And you're not merely rehashing matters that you explored at trial. You don't want to rehash. Okay, so you really do have to meet the grounds laid out. I'm going in the rule. I want to cite also, I thought the Freemon case is good. That's a 4th DCA, and that's a 46 Southern 3rd, 1202, and that's a 2010 case. And just want you to know the standard of review involved here. Because a trial court is accorded broad discretion in determining motions for relief from judgment, the standard of review of an order on a motion for relief from judgment is whether there has been an abuse of the trial court's discretion. So it's an abuse of discretion standard, which I believe is a fluid standard. So all depends on your facts, your case. The panel that you get, everybody has a different opinion on what abuse of discretion means. Now, so that the orders on a 1.540 motion, they're appealable, but they're appealable as an appealable non-final order. So you go by Florida Rule of Appellate Procedure 9.130 sub A sub 5, where the appellate rules directly authorize a direct appeal or non-final appeal from the trial court's order on your motion to vacate. Now, something you need to know about that is that 1.540 governs relief from a final judgment, a final order, or decree or proceeding. The general rule, it has no application to a trial court's non-final order. So if you do a 1.540 motion against a non-final order that the judge is rendering prior to final judgment in the case, generally the other side's going to move and say, hey, this isn't the right remedy here. I'm going to cite, this is an older case, but there are other cases, a lot of cases like this. DOCV Ratliff, 552 Southern 2nd 302. That's out of the 2nd, 1989. So the general rule, you can't direct it 1.540 to a non-final. But then you get into the question, is the order that it's directed to final or non-final? And you often see, the cases with multi-count complaints, you get partial final judgments, but I think we covered this in another discussion. But the question is, has judicial labor ended as to a particular party? So you may have several defendants in a case, you may have several counts, but if the 1.540 is directed to an order that disposes of the case as to the party, then you should be on good footing. So that, in a nutshell, just some of the finer points when proceeding to seek a relief, a post-judgment relief under Rule 1.540. So I think that's a great rule, fascinating rule. It really can help you on a lot of cases. So that's our topic for today. Of course, any questions, comments, feel free to contact us because there's always a lot more to it, but at least this is a good foundation to get you started. Thank you again for joining us, and we hope to see you next time. Hi, I'm Jennifer Carroll, and I want to thank you for watching our video. You can see more of our videos right here. Or better yet, subscribe to our YouTube channel below so you won't miss a single one.